Great word.
Okay.
Sir, Madhavi,
Uh,
right?
yes, sir. So may I start session, sir?
Yes,
Yeah,
yes.
please, please. In all, there are six paper presenters in this session.
Yes.
Yes, sir.
Sir, before that, Nayandara,
Yes,
Please,
sir.
sir.
I would like to share
Sure, sir, sure.
my uh, compliment to my beloved friend, Professor Dr. Raghunatha Reddy, sir.
Another sir, one.
Sir, it is a very great honor for the VIT School of Law to have your presence in this international conference. Really, it is a very great moment, sir. I know, sir, for the last 12 to 14 years, an expert, a renowned academician, particularly in the field of international law, and he was occupying several positions in Tamil Nadu Dr. Ambedkar Law University as Dean for School of Excellence in Law, Director for the Research Department, and he is the head of the Department for International Law, occupying several positions. After his retirement, he became the Dean and also the head for the School of Law in Bharat University. Sir, it is an honor for VIT School of Law to have your presence. A very simple, humble academician, sir. You are my beloved friend. Your contribution for the development of legal studies is really praiseworthy. On behalf of the management, the faculty members, the students of the School of Law, VIT, Chennai campus, I extend a very warm welcome to you, sir, for this international conference.
Thank you, sir. Thank you, sir.
Sir, your presence will definitely enrich the participants and also our students. I am really very happy to see you, sir, in this conference. Welcome, sir. Welcome.
Thank you, sir. So kind of you. Thank you, sir. Thank you, sir, for your
Thank
nice
you.
words.
Thank you, sir, for your warm welcome. So, let me introduce you formally to the session, sir.
Please, ma'am.
Professor Dr. A. Raghunatha Reddy, the Dean of Bharat Institute of Law, joined as the head of its department of 1920. Earlier, he was a dean and director and the in-charge vice chancellor at Tamil Nadu Ambedkar Law University. He has a total of 30+ years of experience in teaching UG and PG streams. As a Dean Research, as a Dean Research in Studies in Ambedkar Law University, produced a number of PhD streams in law, participated, presented, and organized so many national and international conferences, seminars, workshops, etc. Completed 2 UGC major research projects and 1 minor research project. Visited USA, UK, China, Singapore, Malaysia, and Sri Lanka on academic assignments. And he is also served as Senate or Syndicate member of the Tamil Nadu Ambedkar Law University for the 2 terms, having a long administrative experience. We welcome you, sir. It is my pleasure to welcome you to the session.
Thank you, ma'am.
So,
Thank you.
so shall we move on to the session, sir?
Yeah. We'll start the session, madam. In this technical session, there are 6 paper presenters, I think.
So currently, 5 people will be presenting today, sir.
Okay. So, how much time, ma, we need to give for the one paper
Uh,
presentation? How much
10,
time?
10 minutes each for each presenter, sir.
Fine.
At the last 1 minute, I'll be informing them, sir.
You call the first paper presenter to make presentation, ma, please.
Sure, sir.
Yeah.
The
Thank
first paper is presented by Mr. Ankit Malhotra and Rahul Praveen Desarda on the topic Torture, India and International Law.
you.
Respected members, respected sir, Dr. Reddy, Dean Bandyan. It's an honor and a privilege to be one of the youngest speakers at this conference and to represent my university once again, the OP Jindal Global University in Sonipat. My name is Ankit Malhotra. I am the co-founder and president also of the Jindal Society of International Law, which is a student-led initiative under the aegis of the Center for the Study of United Nations. I am actually waiting on my co-author to join, so I request the organizers to please kindly add him to this room because we haven't been able to get him to this
Yes, sir. Yes,
meeting.
sir. We are trying, sir.
Please.
Yes.
But in the interim, let me just continue by thanking the university to present this opportunity to us young students to share our thoughts and perspectives on this completely dynamic issue. As a matter of fact, Professor Chimney is teaching me a course on the third world, the international law and the global south, so it is refreshing to hear him on a Tuesday, Friday, and also on a Saturday. I thank the organizers once again for doing this.
Ankit,
Yeah.
Mr. Rahul Desarda, your co-presenter, has not joined the meeting yet.
Well, I've shared the details with him, so can you, I mean, there's not much besides that I can do.
Only if he joins, we can add him in this breakout session.
I've messaged him and I'm trying to get to him again. In the interim, why doesn't someone else proceed and then perhaps we can speak second? I think in the paucity of time that might help everyone.
Okay. Ma, Naintara, you call the next speaker, ma. Hello.
Yes, sir.
You call the next speaker, ma. Next
Okay.
speaker. Next speaker.
As the next speaker, I wish to call upon Professor Shauri Anand Singh, Faculty of Law, Delhi University, to present the paper on the topic Conflict Between Human Rights and Diplomatic Immunity, a Need for Common Ground.
Can I share my screen?
Yes.
Yes, sir.
Just 1 minute. Is my screen visible?
Okay. Right.
Okay. Good morning, everyone. Respected Chair, respected Dean, sir. I'm Shauri Anand Singh, Assistant Professor in Faculty of Law, University of Delhi. My topic today is conflict between human rights and diplomatic immunity, a need for a common ground. Now, we are all aware that diplomacy is something which is running the world today. And the origin of diplomacy, if we see, it's very, very old. I can call it one can say it's time immemorial. But from recorded history, you can see even the Greeks had sent ambassador Megasthenes to Ashoka's kingdom. Syria and Egypt, exchanged ambassadors right in 298 BC. Ashoka sent ambassadors to Ceylon and Egypt and Macedonia in around 273 BC, and these are all in recorded history. Even before that, once we settled down and civilization started, how human beings or kingdoms started interacting with each other, they found a common means. Okay, let's send someone who will interact on behalf of our kingdom or country or tribe or clan, whatever name you can call. So of course, the origin is from, we can trace it right from the start of civilization, once we started settling down. Now, what does diplomacy mean? Now, many scholars have defined diplomacy. I would not go into the nitty-gritties of the definitions as to how many, there are many definitions of diplomacy, but we can say, I mean, one small definition that I like is by Harriet Nicholson, is that management of international relations by means of negotiations. Now, also, one can say that diplomacy is basically protecting your national interest by peaceful means. The word diplomacy is Greek in origin, which comes from the word diploma, which means making into two folds. But of course, once modern nation states grew, the word took a meaning where it basically means negotiation and you talk to each other. And today, when we talk about diplomacy in common usage, immediately the connotation comes to our head is it is something peaceful rather than going to war or fighting. Okay, let's talk it out. So more of the focus is on negotiation. Now, so of course, if you can see the first slide, I've put in a cartoon which says, I told you to try diplomacy first. But then what happens, and that actually raises the question, why do we need diplomacy? Because it opens up a channel of communication. You can resolve your conflicts, your disputes through negotiations by peaceful means, by give and take, rather than going to war, which will lead to more misery and misfortune. And what is the need today? Of course, with globalization, the importance of diplomacy has increased exponentially. We are dependent as nation states on each other because of the huge dependency of trade. We are now most of the countries of the world are now, more dependent on each other because they don't produce everything. They produce only those things which they are efficient at, and they import those things which they are not efficient at. So if you don't have diplomacy, if you don't have channels of communications open, these the globalization actually will fall apart. Now, if you look at how these countries are expanding their consulates, countries are opening up more and more consulates in different cities because the embassy deals with the core diplomacy work, but the consulate deals with more of economic aspects of economic diplomacy and giving visas for trade and this and that. And that shows the need of diplomacy with time has increased. Though many scholars keep on saying, okay, the old diplomacy is dead, and now diplomacy is being run directly by the head of state through Twitter and this and that. Like when Trump was the president, they would the Twitter handle was very famous because he would lay down the foreign policy without consulting his cabinet or the core diplomats of his team and say, okay, this is United States foreign policy. Now just look at President Trump's tweet. But that's not always true. That was one exception. Hardcore diplomacy is still existing, and it has a lot of importance till date to go ahead in time. So of course we can't say that the importance of diplomacy is decreasing in modern age. Rather, I am of the school of thought that it is becoming more and more important to prevent conflicts, whether economic or of course war. Now, codification. Now, before I go into codification, just to introduce that, why do we talk about immunity? See, the very aspect of immunity is old in origin. That there are many theories. One theory is of extraterritoriality, another is of representative character, then there is functional necessity. Without even going into the theories, that one assumes one major theory is that diplomat basically is the ambassador, is the extension of the sovereign himself, and sovereign enjoys immunity. Now, why did nation states accept that, okay, we will not harm the ambassador? Even if you look into our Indian context, you see when we use the concept of doot, the messenger, even if the messenger is from an enemy state, you don't harm the messenger, right? So there are instances in Mahabharata, instances in Ramayana, in our scriptures, in our culture, that we don't harm the messenger, you don't kill the messenger. And that's like, a common accepted term. And it became, of course, with state practice. Codification came on much later, but with state practice, this, really got acceptance through time. And how did codification start? Now, codification can be traced back, you can trace it back right further also, but you can at least go till 1815, from the Congress of Vienna. ILC relied on a lot of things for codification. Most of it basically was on, state practice. And then there was a code written by Blushchely in 1868. And then there was a draft convention on diplomatic immunity in 1932 by the Harvard Law School. But the codification actually gained momentum after World War II. And the ILC started the drafting process, and in 1961 when it was ready, but yet it entered into force around 3 years later in 1964, and India joined in 1965. Now, once this Vienna Convention on Diplomatic Relations came into existence, that really changed things in terms that it is not that the diplomats before the VCDR did not enjoy immunity and privileges. They did, but it was more of customary international law, more of state practice. But once codification came, it did one very important thing. Was this instrument is very important, is basically because it is one of those rare instruments which gained a sort of universal acceptance in a very short period of time. Most of the countries ratified it. Well, some countries did go for reservations, many reservations, but most of the countries by and large did ratify it, including India. And we also, in 1947, we passed the Privileges and Immunities Act to implement it in our countries also. But though we, India signed it in 1965, I mean, we entered it quite late. But since we were a part of the UN,
recording in progress,
we went ahead with that. Now, what are the privileges and immunities diplomats enjoy? They enjoy a wide range of privileges and immunities. If you look into Article 29 itself, it says personal inviolability. Now, this itself, that he cannot be arrested, he cannot be detained, he will be treated with respect, freedom, dignity. If you look at Article 31 subclause 1, all those immunities from Article 29 to 36 has to be extended to his family members, and so on and so forth. Now, 29 to 36 actually lay down the list of immunities. So you see correspondence, his papers, immunity from civil and criminal jurisdiction. Now, okay, for immunity from civil jurisdiction is still not that controversial, but what creates trouble, the conflict between a human rights of an individual who is in the receiving state and the immunity of the ambassador or the diplomatic agent from the sending state, when he enjoys absolute criminal immunity, that may sometime leads to conflict. Though the list of immunities or privileges are, it's a long list, exemption from taxes, from public service, his personal baggage cannot be, inspected, and so on and so forth. And if you look into instances, there have been instances where they have, violated this agreement. They have smuggled out people inside diplomatic packages, trying to, escape from the jurisdiction of that receiving state. Now, these things where diplomats do misuse their immunities, they're not always in use, but if you look at instances, there have been many. Now, I've just taken few instances of conflict between, where diplomats have invoked the Vienna Convention, and they have generally got away with it most of the time. Because what happens is, when a diplomat commits, yes?
1 minute remaining, sir.
Okay. So in my paper, I've shared so many instances where British embassy gave refuge to a pop band in Russia, and that Russia said this was violating diplomatic privileges. The third point I'll come to directly. Mr. Fletcher was one of British citizens who was shot from the window of the Libyan embassy. And at that point of time, Gaddafi had taken over, and there was a huge UN cry. But Britain could not do anything, and all those people had to be, expelled from the embassy, and they went back jolly well to Libya without being prosecuted.
Mr.
And another one I would like to point out is,
Mr. Chaudhary Singh, you please summarize your presentation.
Yes, sir.
Summarize your
presentation. Just to summarize the presentation, sir, that we need to have a balance between immunity and human rights. And we can't say that human rights, when we say that in normative hierarchy theory, that human rights are above international law in context of diplomatic immunity, that it is a subset and which falls below, So we need to have a common ground because still laws of diplomatic immunity have not become just cogence. So way forward, maybe amend the VCDR or, have an independent international body to try diplomats who have been, accused of grievous crimes, or compensation can be demanded from the sending state, or can we prioritize human rights over everything else and, take away a diplomat's immunity? Thank you, sir. Sir, you're not audible.
Your presentation is excellent, Mr. Shauri Singh.
Thank you, sir.
We thoroughly enjoyed your presentation. Okay.
Thank you, sir.
Thank you.
Thank
Thanks.
you. Thank you.
Nayantara, you call next speaker, ma.
Yes, sir. Next, Mr. Ankit Malhotra and Rahul Desarda will be presenting on torture, India international law.
Thank you so much, Nandar and Dr. Reddy as well. I request my dear colleague and co-author for this paper to please kindly share his screen so that we can begin.
Can you confirm if the presentation is visible?
We still see Dr. Shori's screen. At least I do.
Can you see this now?
Nantara, can you please kindly help us?
Yes, Dr. Shori, could you please stop sharing your screen?
Oh. Yes.
Yes, kindly stop recording.
We still don't see the presentation. Right now, I think we do.
Yes.
I'll start swiftly because we're short on time and I don't want to eat into the time of others. I'll present a brief abstract of the paper which we wish to present at this august occasion. So the paper which we've authored is discussing the impacts of the global war on terror as a campaign against the international human rights system, and we juxtapose this with the international community and the response which it has got. And since we're all Indians and we belong to a country which we are proud of, we critique the Indian system and the domestic laws which have been adopted vis-a-vis the international instruments available. So in that study, we overview the concepts of torture against the war on terror and examine the role of the international courts and human rights bodies in protecting human rights and their responses to the trend of flexible interpretation in the torture and prohibition introduced by the war on terror. So the first slide, Rahul, if you can go to the first slide, is a famous quote which we reflect by Jamie Mayerfield, who says, and I quote him: "If anything is a human right, then the right not to be tortured, and if if tortured is not wrong, nothing is wrong." I think that summarizes the kind of sentiment which we wish to purport through our presentation as well. The war on terror was a counter-terrorism organization, if one can even classify it as an institution initiated by the United States of America as a response to 9/11. The campaign was riddled with human rights violations, and the response to this, at least in international instruments, was enshrined even before the war started in ICCPR Article 479, the UNCAT, the OPCAT, UNDHR, and even possibly the Article 3 of the Geneva Conventions. Human rights obligations, as we all know, have a universal jurisdiction and can be imposed against any state, even if it has not ratified the prohibition against torture. The global war on terror and the impacts of it in human rights. So the justification which is provided in the language of international law as an instrument to justify their actions is classified in the ticking bomb theory. What this essentially does is a utilitarian theory which justifies the use of torture to save the lives of many, even before if there has these acts have been committed. There are multiple presumptions on which this is based, and the classification of this is the name of combating terrorism to ensure national security, which involved to be a popularly justified except rule to the period after the war on terror had begun. This essentially was a rationalization of torture for countering terrorism, which is embodied in the ticking bomb theory. This also gave a lot of flexibility in torture prohibition obligations, which of course led to a lot of human rights violations. It also created a loophole in the human rights obligations of prohibition of torture, which was recognized by several international conventions. And it was used as legal interpretation of torture and rationalizing the immoral integration methods used by the CIA. And this also warranted the use of torture to extract information to achieve long-term goals of suppressing terrorism, much like the slow-fused bomb instead of a ticking bomb, one in the case of Guantanamo Bay, which has gathered much attention and also litigation. The human rights responses to this are also quite stark. The Security Council formed a counter-terrorism committee with the anti-terrorism resolution of 1373. This reaffirmed the council's condemnation on the attacks. There are also other missions and other institutions which are set up. For instance, the International Commission of Jurists, which devised the Berlin Declarations and was discussed in the prohibition of torture, is a luxury in time of crisis and cannot be derogated. The Berlin Declaration set out the international human rights law, which envisages a reasonable scope of flexibility to states to counter terrorism that digresses from certain human rights limitations. The eminent jurists panel on terrorism, counter-terrorism, human rights was also formed in 2005 to look at this. There is a certain case law which was also discussed in the European courts of human rights and also in the British courts as being the leaders on counts of human rights and international law, which is domesticated in their jurisdictions. I will not discuss these cases in depth, but what I will only say is that it discussed the unanimous judgment in the European Court, which rejected the argument and asserted that the deportation of individuals took place with a real underlying risk of torture is a part of absolute prohibition of torture. The court acknowledged the adversity faced by states in countering modern terrorism. It rejected the approach in the first instance, an exception to lift the absolute prohibition of torture. On the accounts of analysis, I would only like to say that the war on terror has a limited scope. It is subjected to heavy criticisms and success, which has outweighed its failure in protection of fundamental human rights. What is also most stark and most interesting in this respect is the principles and cases which are discussed in the paper which we have written, which essentially reassert the fundamental aspects of human rights and reaffirm the absolute nature on prohibition of torture. Torture is a form of terrorism, however, but there is no justification for the acts which are committed in a response to it. The campaign has also weakened the institution and the power that the United States of America holds. The illegitimate attempts of redefining torture with an extremely highly threshold of brutality to justify, to use illustrative attempts to evade the human rights obligations indirectly or directly so. For this instance, we use a reference by a respected professor or at our esteemed university. This is Professor Stephen Marks. But I will end by saying this and hand over the floor to my respected colleague who speak about the Indian position. But let me just say this, that the domain of international law provides for the lifting of prohibition of torture, and it is imperative for the states to counter terrorism in a manner that does not undermine the values of international human rights law. In the face of this, now let us study the Indian position very quickly. Thank you.
Okay, Mr. Rahul. Mr. Rahul, you please
Can you-
begin your presentation? Huh?
Yes, thank you so much, Ankit, for that wonderful introduction and analysis of the global war on terror's position regarding this. I'll continue now. Can you hear me? May I confirm?
Yeah, it is audible.
Yes. So I'll discuss India's position vis-a-vis the global war on terror and its position regarding the law of torture and how does that reconcile with international law. Now, in our primary argument, we submit that in order to understand India's position, we not only have to look at India's domestic laws, which have in a way incorporated practices against torture, but also look at India's response on a multilateral level and how that response first has been elicited from the Indian government, and secondly, how that response has been taken by the other countries in this scenario. Now, after 9/11, which was perhaps the most significant event of terrorism, which affected not only the institutions of United States, but also several institutions across the world in terms of economic impact or rather political impact. Now, post 9/11, what we also saw was a rapid increase in counterterrorism from not only countries based in Asia, but also in the subcontinent, specifically India. And we focus specifically on how India's response deals with the law of torture in general, and particularly international law. Now, it is crucial to know that India is a signatory to the United Nations Convention Against Torture. However, it has not ratified that convention. Now, here we have to understand the difference between being a signatory to a convention and ratifying a convention. And for this, we have to look at the Vienna Convention on the Law of Treaties, which came into force in 1969. and also reflects customary international law. A state party which is signatory to a treaty is not bound by the obligations that the treaty creates, but it has an obligation not to violate the spirit of the convention or to commit any such act that would go against the spirit of the convention. Therefore, although India is not bound by the specific obligations under the Convention Against Torture, such as extraditing those individuals which commit torture, it is an obligation. Now, this also goes to India's reluctance in framing international treaties and it being a core part of Indian government's agenda. Not
1 minute remaining.
yes, thank you so much for that reminder. Now, briefly, I'll discuss why India's domestic laws, or rather the lack of thereof, creates a significant problem regarding India's international obligations. Now, Indian government has enacted, or rather the Indian Parliament has enacted the POTA Act, which is the Act Against Terrorism. Now, the POTA, combined with other rules and regulations, creates a situation where individuals cannot have any resort to an international court or a domestic court to seek justice. And therefore, what we see is the Indian laws do not have a redressal clause. And this we submit as a significant lack in the Indian jurisprudence. Now, I would perhaps end with the significant ruling of the Supreme Court in Mullen Territory versus Union of India, in which it emphasized that the right to life includes the right not to be tortured and therefore is protected under Article 21 of the Constitution of India. To conclude, and if I may just conclude in 10 seconds, we submit that in order for India's obligations to be reconciled with the international law of torture, India first needs to ratify the United Nations Convention Against Torture, and secondly, needs to incorporate certain practices that are consistent not only with the treaty but also customary international law. And this would be India's first step towards recognition of the law of torture as a core part of the law of international human rights law. See that my time has expired.
Okay, okay. Thank you, Rahul. Desarda. Thank you. Thank you.
So, shall we move
Ma,
on to the next
Nainta,
presenter?
Nainta, you call the next speaker, ma?
Yes,
You
sir.
call the next speaker.
The next speaker will be Ms. Maxi Khoi Thong from University of Vietnam. She will be presenting on the paper The Principle of Equality, Non-Discrimination in International Human Rights Law and the Problem Incurred in the Pandemic and the Practices in Vietnam.
Hi everyone, my name is Chung. Good to see you all. Today I'm here to bring you about the principle of equality, non-discrimination in international human rights law and the problem incurred in pandemic and practice in Vietnam. Non-discrimination is fundamental principle of international law in general and human rights law in particular. The principle of non-discrimination does not allow any discrimination to affect the accessibility of individuals or groups to human rights or any form of discrimination on the ground of gender difference. The principle of non-discrimination is applied to all people and all rights. It must be respected in all circumstances, including emergencies and armed conflict. Inequality and discrimination in the distribution and access of vaccines are the cause of the prolonged pandemic. In the context of the pandemic, the right to access to vaccines is almost a part of the right to life. Nevertheless, while accessibility to vaccine is very easy in the United States and developed countries, but it is very difficult in developing and poor countries. Stigma and discrimination have appeared in many previous pandemics, such as the HIV pandemic, Ebola, and Zika virus pandemics, and now the COVID-19 pandemic. COVID-19 pandemic is not merely an health problem. It can also become reason for xenophobia, hate, and exclusion. This discrimination could weaken social cohesion and isolate these vulnerable groups in social. Thereby, the parties may hide their illness to avoid discrimination. People with the COVID symptoms are hesitant in seeking immediate health care. As a result, the virus is more likely to spread, leading to more problems for affected people, and the pandemic becomes more serious and uncontrollable. The COVID pandemic has increased inequality in most areas of social life. The COVID-19 pandemic profoundly affects women who are at higher risk of losing their jobs. Government, while they still have burden of taking care of families and children as the schools are closed. It can be said that the COVID-19 pandemic has raised an unprecedented risk as inequality is increasing at the same time in most countries. The pandemic caused jobs loss, and deepen the gap between rich and poor. The COVID-19 leads to unequal access of individuals and minority communities to information as most government statement and information is provided in only one common language and shared through mainstream media. In Vietnam, despite the economy being seriously affected, the national government has constantly sought to assist all Vietnamese people with the difficulty they are experiencing, so that no one is left behind. This includes welcome every Vietnamese to the homeland. Every two on flight, many people carry the virus, and the unprecedented package of social security support to reduce difficulties for all classes affected by the pandemic. In addition, in the awareness campaigns for pandemic prevent and control media force have led participants together so anonymously and drastically and during this time from official newspaper as social network. However, when the pandemic is still complicated, Vietnam with limited economic potential face many difficulties. Many poor students have not been assisted. The limited number of vaccines leads to slow vaccine rates. The COVID pandemic has been negatively affecting the rights to work for children and children with disability. Vietnam has made great efforts ensuring a balance between implementing urgent measures to prevent the COVID-19 and respecting the commitment and legal obligation in implementing international law. The constitution and national laws under complicated and unpredictable context of the COVID-19 pandemic. The economic potential development level of country and the great effort that Vietnam has made in guaranteeing human rights under undeniable. However, the spread of COVID-19 and its negative knock-on effects are still huge challenges in the next test. My present is N. Thank you.
Okay, it is over. Huh? Okay, very good, ma. Very good. Mekti, you have presented very well. Huh? Mekti is a paper presenter from Vietnam. We like it, ma. Very good, very good. Thank you. Thank you, ma. Naintara, you call on next paper presenter, ma. You call
Yes.
next speaker.
Yes, sir. Yes, sir.
Thank you, ma. Mekti. Thank you.
Ma'am, Maxi, can you please stop presenting so that
Thank
my
you, ma.
presenter can?
You call next speaker.
Yes, sir. The next speaker is Ms. Hepzibah Belua C. She's the assistant professor from the Government Law College, Vellore. She'll be presenting on the topic Globalization and Labor Rights, a comparative study of retrenchment in the information technology sector and banking sector.
A very good morning to one and all. Hope I'm audible.
Yes, ma'am.
A very good morning to Reddy sir. Happy to see you
Okay.
after a long time, sir. Good morning, sir. And I also pass my wishes to Soundrapanian sir. He was my labor law professor in 2005. So it's a great privilege to present my paper before two giants, I should say. And I thank all my friend Anand and other organizers. It is a pleasure to listen to all of them. And I'll quickly present my topic and wind up. Good to see you, Soundrapanian sir. Thank you so much for the opportunity.
Congratulations, ma. Congratulations. I'm very happy to see you.
Being a
Welcome.
student, it's really a privilege to meet you, sir. Thank you. So, today my topic is about globalization and labor rights. And I'm a labor law, my major is labor law. So, whenever I see something about labor rights or labor law, I try to present a paper on that. And this globalization and labor rights is one of is my thesis topic as well. So my thesis is about privatization, private sectors where retrenchment is being done in a different way. Retrenchment, we all know, is redundancy in another word, where the employees are sent out of their job and retrenchment procedures are being followed as per the ID Act. But after globalization, this all happened after globalization. After globalization, we have a lot of IT companies which have come in, a lot of banking sector companies, all foreign companies which have moved in. But when it comes to retrenchment, their policies are totally different. So when we take IT sector, they have a system called bench mechanism. If you have friends in the IT sector, you would have heard about it, bench management and benching. When there is no project, these employees are placed in a place where they call it bench. It is not a place, it's the same workplace, but they don't have any work. So they call it bench, where they don't have any work. The salary is paid partially, and after a few months, they have to leave the job. So they have to wait for the next project to come in. And another mechanism is called as performance improvement plan. These are things which are not known to outside people, especially to lawyers. So in this performance improvement plan, what they do is when the employee is not performing well, they place them under the performance improvement plan, and for 6 months they are being trained. And if they do not perform even after the 6 months tenure, they are being sent out of the job. So these are things which are called as retrenchment, but retrenchment procedures are not being followed. But till 2005, I should say, this was not brought to limelight. We were not aware of it. Only in 2005, when a recession happened, we all came to know that something like this is happening in IT sector and all the sectors. We all saw in newspapers about layoffs being done, mass layoffs. It's not layoffs, it's a mass layoffs. A chunk of people were being sent, employees were being sent out. Even in my own company, I work in the banking sector, even in the same company, a set of employees tried to work in, they were sent out. Their flashcards did not work and they were sent back home. So this type of retrenchment is not available, is not mentioned in the ID Act. ID Act is applicable to IT sector, any sector. This has been informed by the minister herself in the parliament. So which means that ID Act is applicable, employer-employee relationship is there, and the industrial relationship concept is there, industrial harmony has to be maintained, all this is there, but no retrenchment procedure is totally hire and fire mechanism. That is what is being followed in the private sector. So after this 2008, there was little, after recession, there was little awakening. After that, again in 2015, some more employees were being laid off. That was when some few employees approached the court, Madras High Court especially. Selvant Janich, Joshua case or the Sasireka case, these are the famous cases where the employees approached the judiciary against these giants, these tech giants and all. They approached and said, we cannot be retrenched like this. There is a mechanism. 25G talks about retrenchment procedures. So which means what? They have to follow it. Last in, first out. This was not being followed. Anybody was fired. Anybody in the bench was being fired. Anybody who did not perform well. All these people, they were taken as a sample and they were all sent out of jobs. So this was happening. And so this I took as a research topic, and I took a survey amongst 600 employees. So majority 500 from IT sector, because when you take the ratio, they are more in number. So 500 from IT and 100 from banking sector. So overall 600 employees. So from my overall topic, I've taken a leaf out of the book, I should say. And in that, when you see, I compare the level of satisfaction of the employees with their job satisfaction, with their salary satisfaction, with their job mobility, be it horizontal or vertical, and then job security. When I've mentioned all those statistics in my paper. I've done a lot of statistic TT tests and UNO and all the other tests, and the results show that they are satisfied with salary, they are satisfied with their job, they are satisfied with their mobility, their promotion, other things. But when it comes to job security, these employees are least satisfied. They are scared. Being in a public sector, and those who were in the public sector will know how much job security we have. We are not afraid that our job will, we lose our job. But in private sector, that job security is not there. The level of satisfaction of the employees, be it their age group or their level of their promotions, their designations, anything if you compare, job security is not there. So after going through all the results, the findings that I've come up with is that there should be a mechanism to analyze how many employees are being retrenched. So it's a huge duty on the labor officers, but we have to pin some duty on them so that such things do not happen. So I compared with two countries to find out what is happening. In Singapore, if you see, there is a mechanism called early alert. So you can also have an app called early alert, where whatever be the complaint, they can straight away raise a complaint through the early alert app, where the Ministry of Manpower gets to know what is happening. The same way when you go to Germany, their notice period, here in India we have a notice period of 30 days. So but there in Germany they say, if the employee works for 30 years, you should give equivalent notice period. It should not be 30 days. Like a person working for 2 years cannot be compared with a person working for 30 years. So that is the comparison level that Germany has. So the same way, some amendments have to be made. And one thing which we all do not know is about the golden handshake. There's a mechanism called golden handshake, where the employer will call the person and they'll say, we give a huge severance pay. Severance pay is an amount that they pay as compensation, and they say it's a golden handshake, you can leave the company. So such a mechanism is also not mentioned anywhere in the IT Act. So these are things which have come into play after globalization. That's the reason we say we are not against globalization, but we are saying please follow the ID Act and the rules and the legislation that are enacted in India. The last point I would say is about the new code. We have this new Social Security Code of 2020. Perfectly, we have under section 139 something called career centers. So under the career centers, job opportunities are being provided. What we are saying is, please help the people or the employees who are being retrenched. Place them in the priority list. Let them first get the job, and then later on the others who are being in the line. So this is some amendments which we are recommending under the Social Security Code as well. So overall, if you see, we all come under the umbrella of ILO, International Labour Organization, and the International Labour Organization says that there should be dignity at work, there should be decency at work. So like how we have dignity at work when we enter the job, when we claim dignity while we are in job, at exit also we need to give them dignity. That's my thesis. Thank you so much. Thank you, sir. Thank you. Thank you for
Thank you, ma Hipsiba. Thank you. Wonderful presentation, ma.
Thank you, sir. Thank
Torrential presentation.
you. Thank you, sir. All your guidance, sir. All from Soundra Pandyan, sir.
You have done a lot of research. You have done a lot of research, on this topic.
Thank you, sir. Thank you, Anand.
Right. Keep it. You call next paper presenter, ma? Nayantara?
Yes, sir. Next presenter is Dr. Balaji Naika, BG. He's an assistant professor of law, Delhi University. We're presenting on the topic the protection of refugees in India and international level, a critical analysis.
அதெல்லாம் நம்ம ஃப்ரெண்டு சார்.
Thank you. Is my screen visible?
Yes, sir.
Okay. Respected chair and the dear panelists. So before begin, I would like to thank the GWoT Law School and the organizing team for giving me this opportunity to share some of the views on the protection of refugees, both at the international level as well as at the Indian level. So the topic of my today's presentation is the protection of refugees in India and international level, a critical analysis. So before begin, what are the mechanisms we have at the international as well as at the Indian level? So first, let's understand what the crisis is and how Indian international community is responsive to this crisis. So the refugee crisis, as you know, one of the global problems and is also a threat to the international peace and security. And whenever there is a conflict happen at the international level or at the domestic level, so there are a lot of refugees. The refugee crisis, the problem of refugee will rise. So recently we have seen the Syrian refugee crisis. We know that the Rohingya refugee crisis, Afghan refugee crisis. Now you have the Ukraine refugee crisis. This the problem of refugee is continuing one, and there is no proper effective mechanism at the international level, even at the domestic level. So when you talk about this problem, so on the one side we have a big problem of refugee crisis, on the other side how the international community responds to it. And the refugee crisis at the international level, we have two major, the national and the legal and institutional mechanism we have. When we talk about the international legal mechanism, we have the 1951 Convention on the Status of Refugees. This is the broad, the legislation, international convention we have to protect the rights of refugees. And also we have the institutional mechanism called the United Nations High Commissioner for Refugees at the international level as an institutional mechanism. So what is the role of the normative and institutional mechanism? I'll come to that bit later. So before going to that, so how the developing countries are facing this problem of refugee crisis? We know that when the Syrian refugee, any crisis, whether it is the Syrian refugee crisis or Rohingya refugee crisis, it is always the Western countries are not interested to share the burden of the problem of refugees. So most of the time we heard that the Western countries always take the pride of champion of human rights, but when it comes to the addressing the problems of human rights or protecting the needs of the vulnerable community, the developed countries will not come to protect these people. So that's why the developing countries are facing more problem than the developed country when it comes to the refugee crisis, because the developing countries hosting large number of refugees. Whenever the refugee problem occurs, we know that the Western countries close their border. When Syrians wanted to go to the West, US or England, they closed their border. They were not interested to welcome the refugees to their own country. So because of that, the refugees don't have any other option. They have to come back to the developing country, the poor countries. And the problem is the poor countries don't have a financial ability to host this large number of refugees, and they don't have ability to protect the needs of taking care of the interest of the refugees. And at the same time, the Western countries or the developed country refuse to share the burden of refugees. So this is, I just want to highlight how the international community handling this the major refugee crisis at the international level. So broadly, I will divide this presentation into the two parts: one at the international level and another one is the how India sees the refugee problem and what are the mechanisms we have at the Indian level. So briefly, I just touch upon what is the India's position. we know that in India we don't have any law on refugees, and neither we are party to the 1951 International Convention on the Refugees. So we are not party to the international, as well as we don't have any domestic law on refugees. But at the same time, even though we are not party to the 1951 convention, we are hosting large number of refugees, starting from the partition, then Chekma refugees, then so many refugees are coming from Sri Lanka, and so many refugees. We are hosting large number of refugees, despite of not becoming a member of the 1951 convention. So this is our position, but India position is now slowly taking a different shape, like the Rohingya refugees. We didn't welcome the Rohingya refugees. We deported them back to their own country. That is like changing our long-standing position on the protection of refugees. Now I'll come to the the specific about what are the laws and institutions there at the international level. What are the rights of refugees are guaranteed under international law, and then I'll come to the India's position. So at the international level, as already said, the 1951 Convention is the major law on refugees. So the 1951 Convention provides, the range of provisions that includes the definition of refugees, that means who are refugees, and then other kinds of we have, apart from the definition, we have other important provisions like the principle of non-refoulement and other range of the rights of refugees. So the definition of refugee is very, very important, because it defines who are refugees. If you don't know who are refugees, if the state do not have a definition to identify refugee, it is difficult for them to provide protection. So that's why 1951 Convention provides the definition of refugee. I quote the definition in section 1, article 1 says, the old
No, Dr. Balaji Naik, you submit your concluding remarks. Brief, very brief. There is a time constraint,
Okay, sir. Okay, fine. So, at the international, as I said, we have a convention. The major provisions are definition, the principle of non-refoulement, and other major human rights provisions. So, that includes the provisions borrowed from the international human rights law, the covenants, CAT convention, we have CEDAW convention. All these provisions are clubbed in 1951 convention that majorly talk about the rights of refugees at the international level. So in India level, as I already said, we don't have a laws or institution, and we are hosting large number of refugees. When India is concerned, in India we have two major laws. The first one is Foreigners Act, and the second one is the Constitution of India. The Foreigners Act deals with the foreigners, that include refugees. Constitution, we have the fundamental rights. Some of the provisions of fundamental rights applicable to non-citizens, that include refugees, like for example Article 14 and 21, etc. And then apart from these two laws, and the role of judiciary is also very, very appreciable, commendable, because the judiciary not only implemented international law into the domestic sphere for the protection of refugees, but also interpreted Indian law to suit the needs of refugees. So I'd like to conclude by saying that so it is high time that, because we need a law on refugees in India, because our government position is changing from time to time. So that's why when we have a law on refugee at the domestic level, it is very easy for to have maintain a standard of procedure, and so and recognizing the international standard principle, that is principle of non-refoulement, etc. So therefore, I would like to conclude and strongly recommend the government to enact a law on refugees in India. Thank you.
Okay, thank you, Dr. Balaji Naik. Thank you for a wonderful presentation. Nayantara,
Yes,
are
sir.
there any other speakers left
Yes,
out?
yes, sir. One more, sir. The last speaker.
Okay.
The speaker is Professor Prithviraj and Atishay Agarwal from NMIMS University. They'll be presenting on the topic localizing the human rights laws, need of the hour.
Sir, I am audible.
Okay.
I will start. First of all, good afternoon, one and all present here. So my topic is localizing the human rights law, the need of R. So I will start with the topic over here, and so the international human rights attorney are more concerned with establishing the universality of human rights with improving their use is addressing local issues. The study emphasizes the importance of making human rights more locally relevant in the facts of economic globalization. Human rights can be made more locally relevant by interpreting current global standards in light of communicating identified needs and advancing human rights in the light of those same requirements. Particularly at the local and regional level, human rights, if made more relevant to local communities, can give local protection for the negative consequences of economic globalization. So now I will tell about the Convention on the Elimination of All Forms of Discrimination Against Women, which is known as CEDAW. The Convention on Elimination of All Forms of Discrimination Against Women is an international legal instrument that requires states to cease all forms of discrimination against women and girls and protect equitable rights of women and girls. So, women's rights were recognized as human rights at the United Nations World Conference on Human Rights in Vienna in 1993. 45 years after the Universal Declaration of Human Rights was adopted and 8 years after CEDAW went into operations, it was the right time when women status and human beings with rights should never be called into question. Not with less, this was a significant step forward in acknowledging one half of humanity's legitimate claims, namely the violation of women's rights as a human rights failure, and emphasizes the link between gender and crisis against humanities. Now I will talk about the national integration of international human rights. So national integration is the awareness of a common identifier amongst the citizen of country. It means that through the individual belongs to different communities, caste, religion, culture, and religions to speak different languages. All them recognize the facts they are one. Now, further, I will talk about the national integration and international human rights in localizing the human rights. So, in which I will talk about the Palermo Protocol for the better, which is known as the trafficking. The Palermo Protocol took one on the difficult work of defining human trafficking for the global community, and is a process is established in image of human trafficking suffers. There is a conflict at the heart of the identification dilemma between maintaining that resource and correctly giving to the most vulnerable victim, typically women, and stereotyping the classification of the victims into this particular groups. So, in 2000, the United Nations adopted the protocol to prevent, suppress and punish persons trafficking, also known as Palermo Protocol. This convention has been widely and universally adopted. Human trafficking is defined under Article 3 of the Human Protocols. It happens when people are recruited, transported, transferred, ruled, and received by uh, those who use kidnappings, fraud, deception, abuse, and authority of authority, or money to get people to do things done for themselves. Now, the role of corporate sector towards development of human rights. CSR has involved into the yardsticks for measuring a company integration into the society. To a certain extent, society today evaluates business on the basis of three CSR scores. Corporate social responsibilities has involved into corporate strategies, accountability, in which a corporation makes a strategy investment in its CSR. Human rights is a
No,
corporate.
Mr. Agarwal, whether Professor Prithviraj is also going to speak. Is
Sir,
is he
sorry
going
for
to
that.
speak?
No, sir, because sir is facing some bandwidth connectivity.
Okay,
He's,
okay, no problem, no problem. No,
yes.
instead of reading, you make presentation. You summarize your presentation,
Okay, sir. Okay, sir.
What are the highlights of your paper, please?
So, sir, the main highlights of the paper is that we are talking about the how the localization of the human rights can be done with the help of all the things included and done internationally, the implementation of international convent of economic, social, and cultural right, which is known as ICESCR, and also we are talking the scenario about the Indian judiciary system, which has played an important role in localizing the human rights, in many cases, the Supreme Court, the Honorable Supreme Court of India, has given the judgment to. I will like to mention those cases also, which we have taken support in our paper to give the to interpret the things. So the Honorable Supreme Court protected and defended inmates' rights by interpreting Article 21 of the Constitution, and in the case of Prem Sekhar versus Delhi administration, that the use of handcuffs and pretor or inmates violates the rights to human dignity. In DK Vasu versus State of Bengal, which is a landmark decision, protects the rights of inmates and establish various criteria for arrest and detention to minimize custodial assault. And in the case of Sheila Basri versus State of Maharashtra, the court addressed the issue of like maltreatment of women in police stations and established specific rules for the protection of women's rights in detention to penal facilities. So
Recording stopped.
at the end, while concluding, I will say that
Recording in progress.
according to this study, a global economy gets more globalized. Human rights must become more localized. Localization was defined as a process in which local human rights demands inspire a more through interpretation and development of human rights norms at all levels, for local to global, and serve as a springboard for a human rights action.
Thank you, Atisha Agarwal. You have presented very well.
Thank you, sir.
Okay. Madam, Nayanthara, madam. Hello, madam. Nayanthara. Hello.
Sir, I'm Aprajita.
Should I summarize all the paper presentations in 5 minutes time, madam?
Sir, Nayanthara is facing some network issues, but yes, please go ahead, sir.
Yeah. So I will make a summarize all the paper presentations in 5 minutes time. Okay.
Yes, sir.
Okay, thank you, ma Nayanthara. Then, so there was a 6 speakers who spoke about on diversified aspects in this technical session, and this technical session went on for more than 1 hour. The first paper presentation was by Shauri Singh from Delhi Law School. He spoke on conflict between human rights and the diplomatic immunity. He was going on covering all the important aspects of the Vienna Convention on Diplomatic Immunities, 1961, how the diplomacy was significant in the era of globalization, sovereign immunity. Mr. Shauri, you have forgotten about the former diplomats who are prosecuted and punished by the International Criminal Court, ICC. Mr. Pinochet, who was the former ruler of Chile, he was prosecuted for international torture. Okay, fine. Then the next paper presentation was by Mr. Ankit Malhotra and Rahul Desarda. It was a joint paper presentation. We thoroughly enjoyed the paper presentation. The presentation was on torture and international law, and Mr. Ankit Malhotra was speaking about Guantanamo Bay. The Guantanamo Bay is a secret prison in Cuba, still it is being maintained by the Americans, especially this Guantanamo Bay has come into existence after September 11th. Barack Obama promised, he was the president of America for 2 terms. He promised that he is going to close the Guantanamo prison. It is a secret prison, but he did not do it. So many detainees are still undergoing torture in this Guantanamo Bay. This is most unfortunate. And Ankit Malhotra has not touched about Abu Ghraib, the torture in Abu Ghraib. It's a very when Iraq was occupied, invaded by American forces, there was all the prisoners of Iraq were tortured. They were paraded in they were nakedly paraded and they were being tortured. There was a live telecast of Abu Ghraib incident. Then I think he has not touched upon the enforced disappearance. Enforced disappearance. I think this is also important. So, in all, he has explained very good about the just cogence from just cogence point of view also. Then the Indian position was being explained by Rahul Desarda. He was covering most important Supreme Court decision in Mullen territory. So it's a very good presentation, well researched paper, serious paper presentation. Thank you, sir. Congratulations. Then the third paper presentation was from Vietnam, Mec she spoke about equality and non-discrimination. She made it very clear that the principle of non-discrimination is at the root of all the human rights. But how this equality, non-discrimination was, was a problem during the pandemic, COVID-19 pandemic times. He was trying to explain regarding the Vietnam context. Then the fourth paper presentation was by Hepzibah from Government Law College, Vellore. She spoke about the globalization and the labor rights. It is her research topic, and it is a very well researched topic. She was continuous, continuous. The flow, her flow was, is very important. That shows how much control she is having on the subject. I appreciate your sincere and honest efforts, Hepzibah madam. Thank you for your wonderful paper presentation, madam. It's a very serious presentation, very well researched work. Thank you,
sir. Thank you.
Thank you. Then there is another presentation by Balaji Naik from Delhi. He spoke on the refugee crisis. Though India is not a party for Refugee Convention 1950, but still India is hosting large number of refugees, and even now we are hosting the Tamil refugees from Sri Lanka because of economic crisis, serious economic crisis in Sri Lanka. So there is a large flow of Tamil refugees from Sri Lanka. They are taken, given shelter in Mandapam. Okay, thank you for your. He spoke about the principle of non-reform also, which is very important under the refugee law. The last paper presentation was on localization of human rights by Atishay Agarwal from Hyderabad and Professor Prudviraj. It is on localization of human rights. He touched upon CEDA, Convention on Elimination of All Forms of Discrimination Against Women, how these human rights have been integrated at the local level. When the Supreme Court started applying all these human rights law into the constitutional field, starting from Visakha case onwards, this true national integration has happened. So this is the true convergence of international law with the domestic law. So I congratulate all the paper presenters. Their paper presentations were very serious, very well researched work. I congratulate every one of you. I thoroughly enjoyed. Hope all others also, audience also enjoyed your paper presentations. I thank you. I thank the management. I thank Professor Soundar Pandian, the Dean of VAT Law School for giving me an opportunity to chair this technical session. Thank you, ma. Thank you, Nayantara. Thank you. Thank you, ma. So kind.
Sir,
Thank you.
Mr. Ankit Malhotra has raised his hand. So,
Yeah, please.
can I answer
Yes,
the question?
please.
Dr. Reddy, you've thanked everyone, but we haven't thanked you for the expert moderation
Work,
and
work, work,
and
work,
the
work. Thank you.
absolutely
Your paper,
wonderful
your
work.
presentation is very well, very well, very
Thank you,
well.
sir.
Serious.
Thank you so much. We were
Yes.
writing about torture. It was a torturous experience as well because there's so much material that one needs to go through. And the aspects
Yeah,
which
Abu Ghraib,
you covered,
when
we've
Iraq
in
was
fact
being
covered them.
occupied by American forces.
Exactly. We've the aspects which you've highlighted about the Syrian refugees and the others also is something which you've covered extensively in the paper. But I just wanted to give
Yeah, yeah.
enough time and specifically focus on the Guantanamo case since it has so much of
Guantanamo.
literature on
Yeah,
it, and
yeah.
also it's just general knowledge of Guantanamo, which is still not shut. And there
Yeah.
are cases in the European
Yes,
courts and
yes.
also in the British courts, which I've highlighted in my presentation along with Rahul on the jurisprudence on these issues. So, of course, it is a matter of time when such human rights issues are taken up in the Indian courts under a PIL as well. Of course, this can only be done under your expert guidance and tutelage.
Thank you, Ankit. Your paper presentation is wonderful, wonderful. You have covered so many aspects. No aspect is left out. We have enjoyed your presentation. Thank you. Thank you, Mr. Ankit Malhotra. Thank you.
Is there anyone else to raise any question or query from the participant?
We'll wind up the session, ma.
Yes, sir.
Okay, thank
Dean
you.
is here, sir.
Thank you, Professor Soundar Pandian, sir, for
Sir,
giving me an opportunity.
I must thank you, sir. I must thank you.
To chair this technical session. It's a wonderful session, sir.
Yes,
Thank you, sir.
yes.
Thank you.
Thank you, sir. Thank you very much, sir. Thank you, sir.
Thank you, sir. Thank you, sir, for this wonderful session. And I do strongly believe that the comments that you have given and the insights and inputs that you have suggested will illuminate the further research of the presenter, sir. So, shall we conclude the session, sir?
Yes.
Thank you, sir.